Good morning, everyone, and welcome to this employment update on fire and rehire. It's just gone 10 o'clock, and I think most people have joined us now, so we will get going. My name's Jo Oliver. I'm a partner in the employment team at VWV, and this morning I'm going to be joined by my colleague and the head of our employment team, Gareth Edwards. As I mentioned, today's session's about the practice of fire and rehire. And we're going to look at the new code of practice that is being introduced this summer. There'll be an opportunity for Q&A at the end of the session. So if you've got any questions, please do put them in the Q&A box and we'll try to get to all of the questions at the end and have a bit of a discussion about any issues that have come up during the course of the seminar. If you experience any technical difficulties during the webinar, please just pass a line in the chat and my colleague Romany will try and assist and try and get you connected so that you can tune in for the whole of the session. So if we look at what we're going to cover today, so we're going to look at what fire and rehire is, so what that practice is, what it means currently, and look at the changes that the code might bring into effect. We're also going to look at the background to the statutory code, why the government saw the reason to introduce it, what will it mean for employers, and then we're going to look at the status and effect of the code, and then Gareth's going to cover some key features of the code and practical tips for you in terms of how you navigate it. So if we move on to the first slide, please. So let's start by considering what fire and rehire is. So it's one way that an employer can change terms and conditions of employment in circumstances where they haven't been able to get agreement from their employees for those changes. So in practice, it's used where the employer can't secure that agreement. It's often because the changes are considered to be less favourable by the employees in relation to their current terms. And so in those circumstances, the driver for the proposed changes is generally to ensure the sustainability of the employer's business. And there's a need to move forward with those changes, even if the employees, after a period of consultation, aren't prepared to agree them. So in response to economic pressures, the employer would want to put those changes into practice. And that might be to modernise their working practices, it may be to improve efficiency, it may be because they're experiencing other challenges operationally or financially that mean that they need to change the terms and conditions of their staff. So fire and rehire can be a useful tool to break an impasse where agreement can't be reached and to move forward with change that is necessary for the survival or sustainability of a business. So fire and rehire essentially involves serving notice to terminate the existing terms and conditions of your employees and offering to re-engage them on new contracts which set out the new terms and conditions. And as you'll be terminating the existing contract, that is in effect a dismissal, and to avoid or to manage the risk around unfair dismissal claims, there would need to be a fair process and a fair reason for that dismissal. And in the case of termination and re-engagement, the fair reason relied on is some other substantial reason, or SOSR. And in order for that to manage the risks associated with the unfair dismissal claim, you would need to show that you'd followed a fair process in applying that reason. And that process would generally involve trying to consult meaningfully with staff before imposing changes through terminating contracts and introducing new contracts. And what the code of practice that is coming into effect, the statutory code, seeks to do is provide step-by-step guidance to employers about how to fairly and transparently consult with staff and seek their agreement to changes before taking the step to terminate and re-engage. So if we move on to the next slide, please. And we look a little bit more at the background to the statutory code. So the practice of termination and re-engagement is long established, and it's only really in the last few years that there's been a lot of focus on, has that process started to manifest itself in a way that is unfair to staff? Has it been misused? Has there been an abuse of the position of power in the employment relationship by the employer by using it as a tactic to force through changes before any real fair or transparent consultation has taken place? So in 2021, the government asked ACAS to investigate fire and rehire practices and to make recommendations about how better the process could be managed and how fairer it could be for employees. So in November 2021, and this time we're still in the pandemic, ACAS published some advice for employers. And that was very much in response to the understanding that the threat of dismissal was being unduly used to apply pressure to staff to force through inferior terms and conditions with little to no consultation around any alternatives or exploring the alternatives to dismissal and re-engagement. And the ACAS guidance was generally for employers to consider termination and re-engagement as a very much a last resort, and to think about their business case, to think about sharing information with staff at an early stage, looking to consider their feedback before pushing through any changes, and being open to the idea of reviewing their plans, changing those plans to accommodate some of the feedback that they may have received from staff before then introducing those changes, or having to go through the process of serving notice to terminate and re-engage if they couldn't reach that agreement. So it was highlighting very much that termination and re-engagement could be an extreme practice, and in the circumstances, it could damage industrial relations, it could damage the trust in the employer if it was misused. And so it should be undertaken in a cautious and sensible way, and always with the consideration of, are there alternatives to this? And then in March 2022, you'll remember that there was quite a lot of media attention on P&O ferries. P&O dismissed 800 employees without any consultation, and this really shone a light on fire and rehire, although technically the P&O case wasn't really a case of fire and rehire, because here the staff were dismissed, but there wasn't any offer of re-engagement to them. There were no offers of new contracts for those staff affected. But it really shone a light on fire and rehire, and there were calls at that time to ban the practice altogether. And that would have really curtailed employers' ability to bring about change, and it could be quite difficult then for employers in circumstances where there were real operational reasons to make those changes. So there needed to be a balance in terms of better regulation of fire and rehire, and also not restricting employers unnecessarily and causing possibly businesses to go under as a consequence of not being able to affect change, or the adverse impact of employers having to make redundancies and lose staff because they couldn't change the terms and conditions of the staff that they had. So the government looked to address the issue around fire and rehire by bringing in a code of practice that would have consequences if employers didn't follow it, but in itself wouldn't create a legal obligation. So in 2023, the government launched a consultation and a draft code of practice, and invited feedback from employers across different sectors, from trade unions and other interested parties such as ACAS and the Employment Lawyers Association, to feed into what a fair and transparent consultation process would look like when an employer is trying to change terms and conditions. That consultation closed in April 2023. And then in February this year, an updated code has been published to reflect the feedback that's been received. And the revised code is due to come into force this summer. There's not an exact date at the moment. Our understanding is that it will be before the summer recess of Parliament, so it should be around July. But it's important now to start thinking about the code if you are intending to start a consultation this autumn, or if you're going to be consulting over the summer period on changes to terms and conditions. It's good to bear this in mind now and to build the requirements of the code into your consultation timetable and plans. So the changes that were made from the draft code to the current version that we have were really intended to make it more concise, more user-friendly, to put in place terminology that is more accessible to smaller businesses. It was very much drafted with large-scale consultations and changes in mind, and used that kind of language previously, but it's been adapted to be more accessible to those smaller businesses now, because it will apply to every situation where termination and re-engagement is used, whether that applies to 1,000 staff or 1 member of staff. So it's important that it feels accessible in that way. Some duplication was also removed from the code, and the requirement for employers to re-examine their business strategy and plans was removed, so that this requirement only applies to a re-examination of plans and not the strategy itself that led to the decision to want to change terms and conditions. And that requirement was moved up in the running order of consultation as well. And Gareth will talk in more detail about what the consultation and what the step-by-step process set out in the code looks like, and how to navigate that, and some of the key changes and features that you'll need to be aware of. So if we move on to the next slide, please, Romy. So what is the status and effect of the code? So it's important to realise that the code itself doesn't create a legal obligation, although it refers to some legal obligations that you will already have and that already apply under employment law. So it doesn't change the law. However, it does advise and set recommendations for employers to explore alternatives to dismissal and re-engagement, and to consult meaningfully to reach an agreement with staff. And there are consequences if you fail to follow the code. And that if you unreasonably fail to follow the code, I should say. So there might be some circumstances where it's reasonable to depart from the code, although you would need to be able to justify to an employment tribunal or court what those reasons were, why it wasn't reasonable at the time for you to follow the code, and what that justification is. So it might be, for example, in circumstances where there is a real financial imperative to make a change immediately, because the business will go under if you don't make that change, and people will lose their jobs if you don't act quickly and have a shorter consultation than perhaps best practice would otherwise dictate. So if you can show and justify with evidence that that was the case, it might be reasonable then to depart from the code, and you wouldn't be penalised as a consequence. But the code does set out what you must and should do under its step-by-step process. And where it says that you must take a certain action or must not take a certain action, that's referring to a pre-existing legal obligation that you might have. So that might be an obligation under the requirements to consult collectively, where you're looking to terminate more than 20 staff. That already exists, and so the code states in certain areas that you must follow those obligations. And where the code talks about should following certain steps or certain requirements under it, that's a recommendation. And whilst you are not duty bound or legally required to follow that recommendation, if you don't, then that would be admissible in evidence in tribunal proceedings if a tribunal was asked to assess the reasonableness of your actions as an employer. So in those circumstances, if you've departed from the code and don't have a justification for doing so, there is scope for the tribunal to award an uplift to any compensation for unfair dismissal claims or other relevant claims to reflect that failure. So there is a financial consequence of not following the code. And in circumstances where you're looking to change terms and conditions of a lot of staff, that financial consequence could be quite significant. If you're looking at, say, unfair dismissal awards for 20 staff, all receiving up to a year's pay in that award, and then that's uplifted by 25%, you can see that that's a significant deterrent from departing from the code unnecessarily. And while some commentators and some sectors have suggested that the code doesn't really have teeth and doesn't have enough bite in terms of enforcement and should have gone further, the fact that there is this scope for uplift in compensation awards, as I say, is a significant deterrent and is intended to ensure that the code is followed by employers. So if I hand over now to Gareth, who's going to talk about some of the key features of the code.
Thanks very much, Jo, and good morning to everybody. So following Jo's description of how the code came to be, published in draft, and the focus on why, I'm just going to go through some of the features of the code and just look at its overall structure and give you a feel for the level of obligation that it creates if you are having to look at changing terms and conditions or engaging some of the areas that are highlighted in regard to consultation. The preamble to the code, it was published, as Jo says, in February. It is still going through Parliament. It's been through the House of Lords and has been approved. It is currently being debated in the Commons at committee stage. There was a reading in the last couple of days where it was debated. The reasons again were reiterated as the government set out in its various announcements about the code, and we're waiting for final confirmation that it's been approved or recommended, and then a date that will appear on the code. Say it's published in draft on the government website at the moment as to when it will be in force. And I suppose as we're going through the various parts of it, and as Jo said, if you're thinking about something over the summer, maybe think about what this best practice looks like, because there are no transition provisions in this code. It will just apply from the day that it's there. But if you're midway through a process, what does that mean? Do you need to go back and think again about some of the information? If you are already, let's say, in the Section 188 consultation process, where you're looking to say, well, we can't reach agreement on changing T's and C's, they have to happen by a certain deadline, let's say at the end of term, beginning of the next term, or whatever it may be, then in those circumstances, are there additional steps? And therefore, I think the general recommendation is to have an eye to the code now. It is published, it's marked draft, but it's fairly unlikely to significantly change, and it's more about it going through the parliamentary process, which is why it's in draft and it's not yet something that's actively being considered. When we look at the code, the preamble makes it clear that it is seeking to provide practical guidance, and it is setting out some best practice as to what is expected within the legal framework. It's seeking to explain some of that legal framework, but it does also say that only the courts can give an authoritative interpretation of the law. So it is not seeking to resolve any quirks of our case law or any positions generally in terms of when does consultation need to start for purposes of a Section 188 redundancy consultation process, or if you're looking at the pension changes, when does that process start? It's not seeking to answer those questions. It's just giving guidance as to the expectation on employers about how they should go about achieving change when it comes to employee contracts and terms and conditions. The code itself is made up of 9 sections. It's pretty much written in plain English, and it runs through a number of different areas. It starts by making it clear that there's an expectation of taking all reasonable steps to look at alternatives to dismissal. So again, you would do that anyway. Joe mentioned if you were getting to the point where you would have to dismiss, and you'd have what's known as an SOSR, reason for dismissal. That reason has got to stack up. It's got to be a reason that's sufficiently substantial that it would amount to a reason for dismissal. So there will be a business case as to why you need to put this change in place. Whether I say it's there's quite a lot of going on in certain sectors in relation to pension changes at the moment that need a contractual change as well. There's obviously evidencing what that is in terms of the cost of the pension provision, cost of alternatives, and why it is that an employer needs to move there, for example. In other cases, such as we saw over the pandemic, the company may get into difficulty and it needs to change its terms and conditions more dramatically, or it may need to make changes to hours or ways in which it works. All of those things may well lead to needing to engage with the code and think through what the business case is, what the information is, and the reasons for it. As we talked about, it applies to any proposed change. So whether you've got changing the contracts of employment of one or two people, or a larger scale change. And I think that's probably where there just needs to be a little bit of focus and maybe review of processes. So if you are in discussion with a relatively small number of people about change, bear in mind the code if you are otherwise thinking that if you can't agree a change, it may be simplest to try and issue a new contract and to achieve the change by bringing the old contract to an end. The code bites in relation to those, as well as larger scale consultation exercises, which we're familiar with if you are contemplating perhaps making dismissals of more than 20 employees, in which case you've got a 30-day consultation period. Or if they're over 100 people, you've got a 45-day consultation period. And I suppose the question, the qualitative decision for employers is how much time have you got? And because obviously the encouragement of the code is to start the conversation early, be aware of your legislation time limits, but basically to be engaging as early as possible. And the code in the third section deals with the information to be provided, and it's an encouragement to provide as much information as is reasonably possible, and to allow time for that to be digested, for there to be consideration and questions, and for there to be a dialogue with that information. That may be more than 30 days if you've got a Section 188 consultation process you're trying to factor in as well. So do you think about the impact that the requirements of best practice put? How easily is it explained as the reasons for the change? What are the alternatives? And therefore, how might you look at those issues? Because the consultation process itself, again, the code looks for that to be meaningful. And it looks again for employers to consult for as long as reasonably possible, and talks about both parties gaining a deeper understanding and understanding of rationale and objectives on both sides. So both in terms of what the employer is trying to achieve, but also in relation to why there are maybe some deep-seated objections from employees as to that change. And in a better understanding of those, or a deeper understanding conversation about them, does that then give rise to thinking about alternatives or way of dealing with things? If those consultations are not getting to a consensus point of view, then the code encourages an employer to think very carefully if they're going to go down the route of a dismissal and re-engagement to achieve the change. And as you mentioned, it's mentioned relatively early on in terms of rehearsing the strategy and also the information in relation to it. And you need to be clear as an employer if you are thinking that is ultimately what you'll need to do, both in terms of your statutory obligations. When do you deliver your Section 188 letter or other letter that formally kicks off, and statutory information that formally kicks off the consultation process? But at the same time, when do you need to start talking about it in terms of people understanding that might be the end of the road and not taking people by surprise? Because obviously, if you go down a course of trying to reach agreement for a fairly lengthy period of time and then get to, but I'm really sorry, but now as we can't reach agreement, we're going to have to impose these terms, that can be equally as damaging to industrial relations and employee relations more widely than people understanding the framework in which you're acting and going through a process. So there's a bit of a judgment as to when you raise it. And there's some recommendations in the code about how you go about involving ACAS and seeking ACAS's advice. As on the slide, the code is in section E, and it says if you are contemplating it, then you need to be clear. You shouldn't raise the prospect of dismissal and re-engagement unreasonably early, or use it as a way of trying to bully your way through to an end result and use it as a negotiating tactic that can be perceived as unfair because it's a threat and people want to retain their jobs, so are then feeling that they've got no option but to sign the new terms. The recommendation, the language of must and should is rehearsed at the beginning of the code, and see must is a legal obligation, should is a recommendation, and the requirement on employers to think about contacting ACAS is phrased as a should contact, so it's a recommendation, so it may not be appropriate in every case, but you have to think very carefully about why. And it is to contact ACAS for advice if you are considering having to go down the route of dismissal and re-engagement. We've contacted ACAS because we can't see there's much guidance out there yet as to the type of things that ACAS may ask an employer to think about or can help with. Obviously, they can help with conciliating a dispute, and that's a process lots of you will be familiar with. But in terms of this obligation under the code, what is ACAS going to tell you that maybe we haven't already told you as advisors, or others have told you, or you have? It's a well-trodden path in terms of you understanding your obligations. All of that will be a qualitative thing, and at the moment, that the feedback from ACAS from our inquiries is that they will be producing guidance and they will be providing training in relation to thinking about the alternatives on the obligations around best practice, but they're not developing or finalising that because the code is still in draft, and so they are waiting for the code to be finalised and published before they go forward with that training. And at the moment, therefore, there's not much feedback from ACAS other than what's already published in relation to the recommended approach from ACAS as to how they're going to assist. But it's certainly in the process you need to think about how you engage with ACAS, whether you need to seek their advice. I say it's a recommendation that you do. And at least initially, I think we would be looking for employers to build that in so there's a better understanding of what toolkit ACAS are going to provide that may be a helpful way of being able to resolve an area where you've got a real disagreement and employers feeling that they need to advance change and achieve that change, and the only way to do that is to dismiss and re-engage. As Joe also mentioned, there's been a sort of reordering and phasing of it. So if you are raising the prospect, and the next section, section F of the code, goes on to say if it's clear that you're not really going to get to an agreement or you're really struggling with that, then rather than just pushing on and giving your section 188 notice that you're going to engage in collective consultation or see through some proposals, it does ask you to just re-examine your proposals. So pause to reflect, take into account what's been said so far, and think through the reasons why you're not achieving change through consensus, and if you were to press on with needing to achieve that change through a legal process, what the risks of that are. And obviously, to mention a couple of the cases where there was a high reputational risk in terms of an employer appearing to be heavy-handed with its workforce in relation to how it went about trying to achieve change. And obviously there are other litigation risks, even if someone accepts a new contract of employment following a notice to bring the old one to an end, there is still a valid claim for an unfair dismissal in there, and there may well be litigation that follows, and all of that brings in terms of issues around how change is received, to potentially damage to employee relations in relation to it. The code then goes on to say that if you are in the fortunate position of reaching agreement, then obviously best practice is to document that and to be very clear about that, and to issue terms and conditions in a way that everyone can understand, and not try and sort of glide over the change in relation and gloss over it. So again, there's a recommendation that you're very clear with employees about what the change is and what it means. And then there's a section that recognises that quite often employers have built into their contracts the right to change the terms and conditions. And obviously that is a contractual right. And if you're doing that, then in certain circumstances, can you rely on that, because you're not then going to be looking to have to bring the contract to an end. The contract envisaged that it may change and you're entitled to do so. And obviously, if they are minor changes, let's say you've got different benefit providers or a tweak to maybe how you want to manage holiday or sickness that is a contractual requirement, then hopefully you can achieve that through the change clause in your contract. If something is more fundamental in terms of change, then you do have to think through as to whether essentially the changes that you're seeking to implement are within what was contemplated in terms of that change mechanism in the contract, and is it still essentially therefore the same contract, or is it going to be so different that essentially it's a new contract? And the sort of dog and Hoover college case that in relation to how those changes are perceived and how things are dealt with. So say Hog and Dover College is the case to just think through in relation to what's the level of change that's being achieved. And then finally, the final section of the code then deals with dismissal and re-engagement, and it reiterates again, as it's already said a couple of times in the code, it's very much last resort. It reiterates the unfair dismissal test. So what is your reason for doing this? Is that a fair reason? Have you followed a fair process in relation to looking to achieve change? Gives some guidance on expectation around the fact that obviously notice periods are engaged, either statutory notice periods or contractual ones, which may be longer. And then also puts an onus on the employer to think through how that change may be managed. So it may well you've got to the point where you need to impose it, but the employer would still have an obligation to think through how that's going to affect employees and the period of adjustment and how it is that they should maybe support that. So if again, maybe there's childcare challenges to a change in hours. So in those circumstances, should there be a phased period to allow someone to make alternative arrangements for childcare, or if there are other reasons, let's say it's a change in location and therefore there's additional expense and there's a period of time of trying to support people with additional commuting expenses or whatever it may be, it's appropriate in relation to that. So that's a real high level summary of the code. The code is about 10 pages long, so it's built down into the sections. And if you are contemplating making change, then it is something that absolutely you should read in draft form. It's unlikely to change hugely in terms of its format now that the government's done its consultation on it, and it can start to build it into your project plans. If we just go on to the next slide, please, Romany, we can look at some of the practical tips around this. As we've mentioned, it's very much the code applies to any size of exercise, and I think it really is understanding within HR teams and with managers that if you've got smaller groups where you otherwise would have managed that very discreetly before, just think about if you're getting a level of objection to change of a few contracts, what that does in relation to how things may be managed and how the code is, the expectations of the code are then coming into play. There's a clear statement in the code that if you have got a redundancy situation, as in the reasons why you are going through a process is because you need to reduce your workforce, that is outside of the scope of the code, and the general guidance and expectations around redundancy are there. However, if you are combining redundancy with a change of terms and conditions, then obviously for those where there is change, the code does come into play in terms of how you manage that process and the expectations. I've touched on the unilateral changes, and as I say, I think you, as a practical tip, if you have got that right and discretion in your contracts of employment, just think through what the change is. Be mindful of the Hog and Dover College case in terms of whether it's essentially a fundamental change that could ultimately therefore lead to a termination of the existing contract, and just make sure that you're within the boundaries of what the code expects in relation to that. And if you are having to look at making change, then think through how you build the steps into the code. As I say, it's built into a number of sections, and they are incremental in terms of how they look at how you would look to deal with it. And I think the main thing is partly the transitional thing. So if you've got something at the consultation underway already, then to what extent do you need to be taking into account the code in relation to the information sharing and the level of consultation that's in place? You've got until July essentially to operate under the existing rules without this additional layer of expectation and best practice. But it may well be you want to build it in, and it may well help you to be looking at the code at this stage. So think about that, and think about the timing of what you're achieving. So if you are starting something that you know is going to go past July maybe into the summer, when the code then will be active and therefore will apply in terms of the uplift that Joe mentioned. If someone then brings an unfair dismissal or discrimination claim and the risk of an award being reviewed and uplifted, then where does that risk sit in terms of whether you then need to factor in the code or think about things in a slightly different way in terms of how otherwise you might have approached the project. And if we just go to the next slide, we just thought through, because whilst there's lots of guidance in the code, obviously ultimately where this will be tested is in an employment tribunal if someone is bringing an unfair dismissal claim or maybe an unlawful deductions claim or some form of discrimination complaint, where they are unhappy with how the process was managed or the decision was made to change terms and conditions. So as an employer, in terms of leading your evidence to both demonstrate that you've acted fairly in what you've done, but also to see off the risk of an enhanced award, how do you show that? So again, think about how you document things. Think about the language that you're using, and if managers are having to give town hall addresses and otherwise, think about how you document those. But think about when you start and how you phrase things and how it is that you're seeking to achieve change and the dialogue around that change. Absolutely, as you'd expect, we would say as lawyers, keep contemporaneous records of your interactions. If you are following up with ACAS as recommended in the plan, then think about how you do that. Is there an email exchange? Are there good contemporaneous notes of the conversations in relation to that? And this obligation to revisit your plans, how do you evidence that? Because quite often that will be maybe a discussion amongst senior managers. Can we do things differently? Do the employees have a point in relation to certain aspects of what they say as their objection? But you need to find a way of documenting that and having good governance in relation to evidencing that you have gone back and looked at it again and revisited your plans before you implement them. And again, I think what this probably does more widely in terms of the code is that, as Joe mentioned, you'd have an SOSR reason. You'd look at saying why the organisation needs to achieve change. Maybe there's business case or economic factors at play as to why people think that a new contract or a different contract is the way forward. You're going to have to evidence that probably. You'd always have to evidence this, but the code adds a further layer and perhaps makes it slightly more difficult to succeed on an SOSR type dismissal for reorganisation than maybe it was previously, because it very much is the last resort. So have you looked at alternatives to achieving it, timescales, and all of those things which you would have to do earlier? But as I say, I just think there's an additional gloss, an additional level of scrutiny that those decisions will be under in relation to how they've been made. So again, just thinking through that level of challenge and how you would evidence the need for change. Okay, so that was the end of our formal presentation. We said we would take questions at the end, so hopefully Joe can join me again, and between us we'll just go through the Q&A which you have very kindly been sending to us whilst we've been talking. So the first of those questions says, where I'd struggle is the difference between using the redundancy process and following the code. If you're changing terms and conditions, then is the job redundant? For example, the role is broadly the same in regard to suitable, but maybe there's a lower salary that you're trying to achieve because it's been recalibrated, or you may well look at whether there's a suitable alternative, and would you therefore follow the redundancy process? It's very similar to redundancy requirements in relation to what's expected. I think that this is where you need to be very clear at the start as to what it is that you're trying to achieve. If it is that you are saying there's a change in terms and conditions because you have recalibrated roles, so the role is still there to be done, and you very much want to do it, then albeit that you may characterize that as a redundancy in terms of the requirement to do the job at one level has changed and it's now at another level, and it may well be a redundancy, you'd still have to go through, I think, the consultation process and explaining that and looking to achieve change through consensus. potentially before you place that person at risk. Because when you place that person at risk, you are communicating essentially that you're going to dismiss and then re-engage. Joe, are we on the same page on this, or you've got other thoughts that you'd add in relation to how you might manage that process?
I think we are on the same page. I think it is about that business case at the early stages and identifying what it is that you're doing. So is there going to be a change to the workforce? Are you actually reducing numbers? Is it a genuine redundancy? In which case, as you said, Gareth, the code won't apply. But if you're doing a broader exercise in maybe reducing numbers, but also reorganizing the way in which you do things, changing the way in which your business practices operate, then I think it's going to be good practice to apply the code, because it quite clearly states that it applies in situations where terms and conditions are going to change. But if you're offering a suitable alternative role in a genuine redundancy situation, then it's not going to apply.
And obviously think about what is a genuinely suitable alternative in those circumstances, because obviously if there is a change in salary, then largely it's not going to meet the test of suitable alternative for the purposes of redundancy payments in terms of how that process is managed. The next question we've got is, how do our obligations around negotiations and consultation with our recognised unions align with the code? I think the short answer to that is that those obligations continue, and the code absolutely says that you should have regard to any obligations you have in place with unions or otherwise. The obligation to consult is with the unions first, and then if you don't have them in certain groups, then look at elected reps. And what this does is basically seek to inform those existing obligations that you have and the level of negotiation and approach that you need to take. So it seeks to build on and perhaps amplify the process rather than seek to change what your existing obligations are. Next question says, if there is a break in service, if we fire and rehire, is there a break in service if we fire and rehire for the employee? Joe, do you want to deal with that?
Yes, if I can unmute myself, there we go.
Cool.
So ordinarily, there wouldn't be a break in service if you have served notice to terminate and you have issued a contract to start immediately as the old contract finishes. So there wouldn't be a break. Continuity of employment would be preserved. And that's the situation that you would want to achieve for the employee. In circumstances where the employee doesn't accept the new offer or takes time to accept the new offer, or there is a break in service, which is unusual, you might suggest that there has been a break in service, but where that offer has been made whilst the employee is under notice and it's intended to start immediately, there wouldn't normally be a break in continuity, and so their rights would be preserved in terms of unfair dismissal, etc.
Thanks, Joe. Thank you. Our next question is then, what is a reasonable period for consultation on changing terms and conditions of employment? It's a more significant, for example, if you're changing accommodation rights. I suppose we're back to, in terms of whether code is engaged, is ultimately whether you think one of your outcomes may be to look at bringing the contract to an end and then issuing a different contract with maybe even different or no accommodation rights in it. Beyond that, it's a question of fact in every case as to what it is that you're seeking to achieve with your change, what level of engagement you need with those who maybe have those in this example, the accommodation rights, and how you're going to change that. So if you're putting forward proposals to say that we're essentially giving you a year's notice that we need the accommodation or it needs to be vacated for these reasons or whatever it is, because we've got some estate planning issues to do, then it may well be that that would be a relatively short consultation because you're giving a long lead-in period as to then when you implement the change. If it is that you're saying, well, we haven't got any fixed ideas, but we just know we've got plans towards accommodation, so we need to see things through, then it may well be longer because an employee's going to say, well, hang on, that's a fairly fundamental term for me. What am I going to do about my accommodation and maybe family and other things? So you need to think through what it is you're communicating and therefore what's a reasonable time then to deal with that issue. Our next question is, what elements do you think are weakest in the code? Oh, question. Sorry. Someone read another one, it bounced at the top of the screen. What elements do you think are weakest in the code or where employers should be most careful and wary? I think, and I'm not sure there's any particular weakness in the code. I think what it is important to do when reading the code is look at the words must and should, because at the beginning it makes it very clear where they're describing a legal obligation. So a must, you must do this, you must do that, in terms of, for example, having a reason for a dismissal and following a fair process. And those where they essentially, the code is seeking to make a recommendation. And those are the where it says you should do this or an employer should do that. So I'd certainly read it with that eye. I think the role of ACAS is currently unclear, and it's unclear as to, you can involve ACAS at any point in this process, and obviously they're an incredibly valuable resource when you're looking to deal with employee relations issues and you're looking at a conciliation process. But equally, where you have if you're really going to go down the dismissal and re-engagement route, and there is a recommendation that you take advice from ACAS, what that advice is going to be. And at the moment, as I say, on our inquiries, it's not really joined up with ACAS as to what they're going to do. We know that they're a service that has a lot of demands on its time, so we can't see there's additional resource being made available to be able to provide one-on-one support. So is it going to be guidance, training? So it's just a little bit of an issue, and therefore a little bit of weakness in the code in terms of how long will that process take? Will it be literally you get an email in response saying, have you thought about X, Y, and Z, or have these issues, or is it, please make an appointment to talk to an advisor in 2 weeks' time to talk through your situation, and we'll help you pick whether there are alternatives. So for me, I think it's those areas where still some uncertainty. Jo, in your reading, is there anything else that you would think is an area where be wary when giving advice?
I suppose the thing to be wary of is approaching this like a tick box exercise, in sort of going through the sections and saying, I've done something, but you haven't approached it in a genuine and meaningful way. And the whole ethos of the code is to be meaningful in the way in which you consult about changes. So if it doesn't look, or if it appears that you're being disingenuous in that intent, I think that would be something of concern in terms of the uplift and whether what you've done is reasonable when looking at unfair dismissals, for example.
Thanks, Jo. And a follow-up, a slightly different question, but what are the obligations for staff with less than 2 years service? Does the code apply to those with obviously not unfair dismissal rights? I would generally say it does, but have you thought about that?
I think it does, because it applies to everybody in those circumstances where you're looking to change terms and conditions. I suppose the penalty for not following the code is perhaps less in the circumstances where someone doesn't have unfair dismissal rights, wouldn't be able to bring a claim, so wouldn't necessarily be able to pursue the uplift. So when you're looking at a financial assessment of the risk of not following the code, you may feel that there's less risk there, but it doesn't mean that the code doesn't apply. So it's more of a commercial decision.
And remember that the code references the claim. The uplift applies to the claims in Schedule 2A.
The discrimination claims and other claims too. So
yeah. So again, if someone is objecting on family-based reasons, they may have the bones of a discrimination claim. And again, you can see an uplift in those circumstances. So I think it is an expectation. It applies to everybody. And then the next question is can this be used for harmonization of contracts where consensus is low? I think the harmonization issue, quite often if you have merged organizations or you've acquired parts of another business or people have come to you, or just again, businesses have developed over time and you've maybe got different legacy contracts that you're looking to grandfather. In those circumstances, you may well just have a longer term harmonization commitment and not to be wary of equal pay issues and other issues that may come around in the meantime as to whether you are properly dealing with differences in terms and conditions. If you've decided that you really can't, you're not making progress with that, and it is administratively difficult because of payroll or other issues to have different T's and C's in the organisation or a sense of fairness, then it may well be those are all sufficient reasons to start thinking about the consultation, which you've been having anyway, becoming more formal in terms of explaining ultimately whether you would get to a position where you bring some of the contracts to an end to get everybody on the same T's and C's. So I don't think it is necessarily using it for that. I think it's thinking about when it may apply, depending upon the urgency of how you're looking to harmonise and the issues you're trying to deal with in terms of that harmonising. The next question then says that this person has been in a long consultation with unions, and through this we've shared a lot of information with the unions, including responding to a CAC disclosure. How far do we need to reshare all of this information with staff if we start an individual consultation process that may lead to dismissal and re-engagement? Or can we rely on the fact that the union should have shared with members throughout the process? We've been holding some staff briefings about the process to keep staff up to date. Jo, do you have a view?
Because the point of the code is about transparency, so making sure that if you're now consulting with staff on an individual basis, although the assumption is that the information has already been shared, it might be sensible to reshare it or summarise it just to help inform the discussions you're having now and to bring it up to date if things have changed through the consultation you've had with the union. So I think it probably is sensible, and Gareth, tell me if you disagree, but to reshare it or to summarise it.
And quite often that sort of level of process, the information is hosted somewhere, and it may well be it's sufficient to signpost it back, the employees back to where you posted that information. But bear in mind, this is around a consultation process, but you've still got to achieve a fair dismissal, and that dismissal, depending upon what process you're following, may well be an SOSR, as in there's a business change, and that's why you need to implement a change that leads to a dismissal. The code is now going to be scrutinised, and your actions will be scrutinised against that code if that dismissal claim is basically brought after July, when we think that this code will be in place. So from that point of view, you still have to then go through evidencing to the individual the reasons for the need to think about notice, and then the reasons for change, and that you followed a fair process on an individual basis as well as consultation process. So I would say, belts and braces, you may not be having to reshare all the information, but you need to have some really good summaries, and you need to have references back to where you've given information to the unions, or a central repository where people can then understand those reasons, so that you can really evidence that you have gone through a detailed process and thought about alternatives before you get to the point where the final alternative is to look to give notice and achieve change through a different contract. And then I've got one final question, and then I think we should bring things to a close as we're just coming up to 10 o'clock. Must the employee's existing rights earned over a period of service be transferred into the new contracts? Certainly in terms of continuity of employment, that's something you would expect. Again, if you're reissuing a contract, it's not going to interrupt the period of employment, notwithstanding that you're giving notice to bring the old one to an end, providing the employee accepts the new one. So from that point of view, yes, you are looking to honour service for statutory purposes. I imagine you could also be honouring it for other purposes, such as some of your benefits may be tied to length of service or other requirements. I suppose it really then comes back to what is it you're seeking to change, and are the benefits going to stay the same, or are the conditions going to stay the same in relation to the where service is relevant to those. So it'll be back to what other changes that you're looking to achieve. Jo, any final thoughts before we close?
No, nothing more from me.
Cool, brilliant. We've got a little feedback survey which we always ask you to please just complete as to how you found the session useful. They're really useful feedback for us as to just how we pull these together and think about going forward. So feedback is always very welcome. Thank you. Otherwise, I think it just leaves us to thank you very much for joining us today. We hope you found the session useful, and we look forward to catching up with you soon. Thanks very much.